bills happen to be very, very important. And the next court immediately under the Supreme Court of the United States of America. With that, I suggest the absence of a quorum and ask that the time be divided equally.
Without objection, so ordered. The clerk will call the roll.
Mr. Akaka.
Senator from California is recognized.
Alaska would be...
I don't know why I was going to say Senator from California.
We'll discuss that later, but in any event, I ask that the quorum call be dispensed with.
Without objection, so ordered. Morning business is closed. Under the previous order, the Senate will proceed to executive session to resume consideration of the following nomination, which the clerk will report.
Nomination, the judiciary, Goodwin Liu of California to be United States Circuit Judge for the Ninth Circuit.
Mr. President.
Under the previous order, the time until 2 p.m. will be equally divided and controlled between the two leaders or their designees.
Mr. President, I am very honored to speak in favor of the Goodwin Liu nomination and to urge my colleagues on both sides of the aisle to cast a proud vote for an extraordinary person, a remarkable young man who, for want of a better word, is just a star at everything he's ever done. And this is a picture of Goodwin. To say that Goodwin personifies the dream of America is an understatement. To say that this is a good nomination understates the way I feel about it. I thank the President for moving forward with Goodwin on 2 occasions, the nomination twice. Was it 3 times? 3 times. The Judiciary Committee for reporting him out on more than 1 occasion, and of course to Senators Leahy and Reid and Feinstein for their hard work to getting us to this point. It's rather stunning for me to hear conservative Republicans come down here and blast Goodwin, because Goodwin Liu, Professor Liu, has support from some of the most conservative legal minds in the country. And I want to share with you what Kenneth Starr, who is the, we all know, the special counsel on the Whitewater matter, considered quite, at that time, quite partisan. One of the conservative, I think, want to say stars of their thought. He said, in our view, and he writes this with Professor Amar, and this was published, in our view, the traits that should weigh most heavily in the evaluation of an extraordinarily qualified nominee such as Goodwin are professional integrity, the ability to discharge faithfully and abiding duty to follow the law. Because Goodwin possesses those qualities to the highest degree, we are confident that he will serve on the Court of Appeals not only fairly and competently, but with great distinction. We support and urge his speedy confirmation. This is Kenneth Starr So I say to my Republican conservative friends, before you come here and start attacking Goodwin Liu for things he has never done, read what some of your conservative leaders in the legal profession are saying. Today, just today, in Politico, there's yet another op-ed written by Chief White House ethics lawyer under George W. Bush for 2.5 years, Richard Painter, Republican serving a Republican administration. This is what he said. All that is required, he said, all that is required is for Senate Republicans to practice what they preached for so long under Bush. Give Liu an up or down vote rather than a filibuster. Well, we're facing a filibuster. I want the American people to know, and everyone who is supporting Goodwin Liu, and everyone who supports giving young, extremely talented people a chance to prove their mettle, someone who has been a star his whole life, someone who caught the dream. Give this man a chance. Don't filibuster him. Let us have an up or down vote. And I think the ramifications, and I feel very strongly about this, I don't say this very often on the floor, I think the ramifications of this filibuster are going to be long and difficult for those who caused this good man to be filibustered. Unless, of course, we get the votes, the 60 votes we need. And why do I think that? I'm going to tell you why I think that. I'm going to spend the next few minutes talking about Goodwin, telling you about his life and his achievements and his amazing recognition by so many in his short 40 years. Goodwin Liu has been extremely successful at each stage of his academic and professional career. He has reached for the stars, and he has grabbed them. He was the co-valedictorian and captain of his tennis team in high school, okay? Let's start with Goodwin in high school. Now, he was born to Taiwanese immigrants who were both physicians, and they moved to Sacramento. And they were quite an influence on Goodwin. They used to leave out math problems for him to solve, even after he finished his homework. They said to Goodwin, you work hard and you can get what you want if you work hard. They forgot to mention that there's a filibuster that could interfere, but let's not go there because we certainly hope we get the 60 votes. So it starts in high school where you have a co-valedictorian, a captain of the tennis team at Rio Americana High School in Sacramento. Then he goes to Stanford, where he graduates Phi Beta Kappa. Very, very, very big honor. From Stanford. Now, while he's at Stanford, he's elected co-president of the student body. He receives an award called the Lloyd Dinkelspiel Award. It's the university's highest honor for outstanding service to undergraduate education. So, high school, he's a star. He's a star at Stanford. Then he goes to Oxford University, where he was a Rhodes Scholar, which is considered one of the most prestigious academic accomplishments. Following his time at Oxford, he decides to attend law school at Yale University. Once again, Goodwin goes to Yale, and he's a star. He was an editor of the Law Journal. Along with a classmate, he won the law school's moot court competition. He wrote an article during his third year of law school that won 2 awards, one for best paper by a third-year law student and another for the best paper on taxation. He had such a distinguished record in law school that it earned him a clerkship with Judge David Tattle of the U.S. Court of Appeals for the District of Columbia. And then he does so well there, he serves in one of the most prestigious clerkships in the country, law clerk to Justice Ruth Bader Ginsburg on the United States Supreme Court. I say to my Republican colleagues, what are you thinking? We should thank Goodwin for being willing to continue his life of public service. We should be praising his decision to put up with all of this confirmation process. Instead, they've given him a horrible time, an awful time, a miserable time. And I said yesterday on the floor, I addressed his wife and his kids, you be proud of your dad and you be proud of your husband, because I say this, if he doesn't get this, it's about politics. It says more about the people here in this place than it does about Goodwin. Throughout this period, all these attacks on him, all these ideological attacks, frankly, on someone they made him become. This is a man with huge support from conservatives, moderates and liberals. He brings people together because of his personality, his kindness, how intelligent he is, how he listens to people. That's what people tell us about him. And yet still, he's been viciously attacked, and we see politics being played. And this will not be lost on the American people. I'm going to tell you that right now, because this isn't just some guy that the president bumped into one day and said, I think he'll be good on the court. This is an extraordinary American who has fought so hard in every job he ever had to be the best, to bring the best qualities to his work. And that's why he's won the support of former Bush officials and Kenneth Starr, the conservatives' idol. They support Goodwin. Oh, but it's not good enough for politics that's being played around here, and this is not going to go down easy. If he doesn't get his up or down vote, this is not going to go down easy. I have experience in this political world for a long time. I won 11 straight elections. They've all been really, not all, most of them very hard. And I know when there's an issue that touches the heart, and I know when there's a person who comes along who deserves better than what Goodwin Liu is getting from the Republicans. The Republicans here in this chamber, not the Republicans outside. Let me read to you what Kenneth Starr said about this man. Let me read it again to you. The traits that should weigh most heavily in the evaluation of an extraordinarily qualified nominee such as Goodwin are professional integrity and the ability to discharge faithfully an abiding duty to follow the law. Because Goodwin possesses those qualities to the highest degree, we are confident he will serve on the court, not only fairly and competently, but with great distinction, and we support and urge his speedy confirmation. Kenneth Starr. Well, his Republican friends, Kenneth Starr's, are not listening. Speedy confirmation, and this is an emergency vacancy here. This is an emergency because they need to fill this position. What they are doing by playing politics with this is making sure that the people of this country, because the Ninth Circuit is a very important circuit, will not get justice unless they change their mind and come to their senses and do what they said they would do. I won't quote who said these things, but I have heard many on the other side say, oh, we don't want to filibuster judges. Let them get an up or down vote. And then we hear they're not going to vote to give Goodwin an up or down vote. And what's the reason? There's no reason. You cannot find a more qualified person What is the message to the people in this country when you have someone who was a star in high school, a star in college, a star in law school, a star in everything he did, a law clerk? Now, he gave a lot of his life to public service in the Corporation for National Service, where he helped launch the AmeriCorps public service program. As a senior advisor in the program, he led the agency's efforts to build the AmeriCorps program at colleges and universities across this country. Between his clerkships, Goodwin returned to government service as a special assistant to the Deputy Secretary of Education. He won praise from Republicans, from Democrats, from conservatives, from liberals, from moderates, in every position he ever held until he got to this Senate floor, where the conservative Republicans turned their back on Kenneth Starr, turned their back on Bush administration lawyers, turned their back on the facts of Goodwin Liu's life for some agenda, and I am telling you, this will not go down easy for them. This will not go down easy. Goodwin served in the private sector. He worked for a very well-respected law firm, O'Melveny & Myers. He worked on a wide range of matters, from antitrust to white-collar crime. He also maintained an active pro bono practice. Pro bono, did things for free to help people who needed his help. Walter Dellinger of O'Melveny said, Goodwin was, quote, widely respected in law practice for his superb legal ability, his sound judgment, and his warm collegiality. Well, let me tell you, the kind of treatment he's getting here is far from warm. It's cold. It's wrong. It's harsh. I want to read again what Kenneth Starr said. This is the third time. Kenneth Starr, can't get more conservative. The traits that should weigh heavily in the evaluation of an extraordinarily qualified nominee such as Goodwin are professional integrity and the ability to discharge faithfully an abiding duty to follow the law. Because Goodwin possesses these qualities to the highest degree, we are confident that he will serve on the Court of Appeals not only fairly and competently, but with great distinction. We support and urge his speedy confirmation. Kenneth Starr. And again, today, in an op-ed piece in Politico, George W. Bush's White House ethics lawyer said all that is required of Senate Republicans is to practice what they preached. Give Liu an up or down vote rather than a filibuster. But no, we are facing a filibuster against someone who is a star. Do we have any photos on George? Who was that? Okay. So as we follow Goodwin's career, star in high school, star in college, star in law school, everywhere he goes, he's recognized. In 2003, he joins UC Berkeley faculty as a law professor, where he has excelled as a scholar and a teacher. He is considered, in this nation, one of the leading constitutional law and education law experts, but not in this chamber. What do they want from a nominee? Backing from conservatives, backing from liberals, backing from the mainstream. His article on education law issues won the Education Law Association's award for Distinguished Scholarship in '06. He receives the Distinguished Teaching Award in '09, the university's most prestigious award. I have never, and let me say this, I have seen some wonderful people come to this floor for confirmation. Democrats, Republicans. I have seen qualifications. I have voted for Republican judges, for Democratic judges. Honest to God, it's hard for me to recall someone who at every stage of his life, and he's only 40 years old, has been able to achieve such excellence. And what is the message coming from this body if we don't give this man an up or down vote? I'm telling you, it will go down hard. The Bar Association gave him the highest rating. The highest rating. And yet, we're facing a filibuster here. The Goldwater Institute. Everybody knows Barry Goldwater, idol of conservatives. The director of the conservative Goldwater Institute endorsed Goodwin Liu. But that's not good enough for my Republican friends. They said they're endorsing him because of his, quote, fresh, independent thinking and his intellectual honesty. But that's not enough for my friends on the other side. They said they were endorsing him also because of his, quote, scholarly credentials and experience to serve with distinction on this important court. So we've heard from Kenneth Starr, conservative icon. We've heard from George Bush's White House ethics lawyer for 2.5 years, Richard Painter. He wrote today. Let's see what else Richard Painter wrote about Goodwin. These supporters of Goodwin's are passionate. That's why I say this is going to go down hard if we don't get this cloture vote. This is interesting. I've done my share of vetting judicial candidates, he writes, and I fought the confirmation wars. I didn't know much about Liu before his nomination to the Ninth Circuit, but I became intrigued because of the attention the nomination generated. And I wondered if his Republican critics were deploying the same tactics Democrats used against Republican nominees, and they were. If anything, the attacks on Liu have been even more unfair. More unfair. Based on my own review of his record, I believe it's not a close question that Liu is an outstanding nominee whose views fall well within the legal mainstream. That conclusion is shared by leading conservatives, he writes, who are familiar with Liu's record. And that's not good enough for my friends on the other side. Well, I'll give him another quote. Former Republican Congressman Bob Barr. He's also offered praise of Professor Liu's commitment to the Constitution, as Barr put it, and to a fair criminal justice system, as he put it. He noted, quote, Liu's views are shared by many scholars and lawyers and public officials from across the ideological spectrum. But Bob Barr's opinion isn't good enough for my friends on the other side. I'm even going to read you a quote of a former congressman who tried to get the Republican nomination twice and run against me. Tom Campbell. He and I have had a couple of disagreements, but not on Goodwin. Tom Campbell, who served 9 years as a Republican congressman from California, said, quote, Goodwin will bring scholarly distinction and a strong reputation for integrity, fair-mindedness, and collegiality to the Ninth Circuit. Reflecting on Liu's many years of work in serving the public interest, Campbell also said, quote, I'm not surprised that Liu has again been called to public service. So it goes on and on. I'll give you another Republican. Brian Jones, who served as a general counsel at the Department of Education from 2001 to 2005 under George W. Bush after Liu's tenure there, this is what he said about Goodwin that speaks to the heart and soul of this good human being. Quote, during 2001 and 2002, and even after he became a law professor in 2003, Goodwin volunteered his time and expertise on several occasions to help me and my staff sort through legal issues. In those interactions, Goodwin's efforts were models of bipartisan cooperation. Listen. In all those interactions, Goodwin's efforts were models of bipartisan cooperation. He brought useful knowledge and careful lawyerly perspectives that helped our administration achieve its goals. And he says, quote, I am convinced, based on his record and my own experiences with him, that Goodwin is thoughtful, fair-minded, and well-qualified to be an appellate judge. Well, all those wonderful letters, and let me thank everyone who is engaged in this battle, from Kenneth Starr to the Goldwater Institute and all the conservatives that got involved in this campaign on Goodwin's side, and all the liberals and all the moderates. Here is a man whose family came from Taiwan. They taught him every value of family. Goodwin has a beautiful family. They taught him every value of hard work, every value of education, every value of fairness and justice. And why we wouldn't give this man an up or down vote, that's all we're asking. No, they bring out the filibuster. And it's going to go down hard if this man does not get this opportunity. So, Mr. President, this has been an honor for me to stand here for 2 days to lay out the strong support that Goodwin Liu has, not just from the 2 home state senators. And let's keep that one in mind, senators. When you and your colleague in your state are backing a nominee, just keep in mind, don't ever tell us, well, that doesn't matter, because it should matter. Strong support from the 2 home state senators. Strong support across the political spectrum. Strong support by community organizations. And in closing, let me say this. Diversity is important on the bench. Why do I say that? Because America, we are a melting pot, and we're proud of this American dream. But if our court doesn't reflect this diversity, it could still be fair, it could still be just, but not as good as if we have a diversity of thought and ethnic diversity. Now, in the Ninth Circuit, this is interesting, the Ninth Circuit covers an area where 40% of Asian Americans live. 40% of Asian Americans live within the Ninth Circuit boundaries, and we do not have an Asian American judge. Is the Asian American community excited about this nomination? Absolutely. Whether they're Republicans, and many of them are, whether they're Democrats, and many of them are. I think it's almost like a 50-50 split in the Asian American community. Well, pay attention to this. This is a moment. It should be a moment of great celebration. I'm fearful. It might not be. But I am forever hopeful that it will be if people listen and they see the breadth of support of this man and they take politics out of the equation and ideology out of the equation. They will vote for ending this filibuster, and they will vote for Goodwin. Thank you very much. I yield the floor.
President.
The senator from Alabama is recognized.
Mr. President, I would like to speak on the Liu nomination, and I appreciate the good advocacy of Senator Boxer, but I would remind her that she and her Democratic colleagues changed the ground rules of the Senate and created filibusters that had not heretofore been done in early 2000. I opposed that. But after much debate, several years in which a half a dozen fabulous nominees to the courts were being blocked by a filibuster, the Gang of 14 decided that matter and said, well, we all agree now we'll not filibuster except in extraordinary circumstances. And I think as a matter of law, not as a matter of character and personality, but as a matter of approach to law, extraordinary circumstances exist in this case. I've heard my colleagues talk about Professor Liu's unusual intellectual abilities, his academic career, clerkship on the Supreme Court, and his prolific writings. And certainly, I don't dispute he is a good man and is involved in debate about law in America. What they fail to mention, however, is his lack of any meaningful experience as a practicing attorney. He's never tried a case before a jury and has argued only once before a federal court of appeals, only once. This is a very serious shortcoming for a number of reasons, the most important of which is a plain fact that significant legal experience litigating in court provides insight to someone who would be a judge and an understanding that words have meaning and consequences. And it is a real legal world testing ground in which persons can prove their judgment and their integrity and their skill. It also provides a maturing experience where one learns that words have reality and that a single word in a deed, a contract, a letter, or even an email can determine which party received millions of dollars in a lawsuit or even whether they go to jail or not. Seasoned lawyers bring much to the bench, as do judges who've had previous experience when they go on to the courts of appeal. This lack of litigation experience leaves me with only two sources of how to evaluate how this nominee would behave on the bench: his writings, which are extensive, and his testimony before the committee, which, frankly, I never felt too great about the value of those testimonies. From his writings, one cannot help but see that Mr. Liu has extraordinary beliefs about our laws and Constitution, beliefs that fall far outside the mainstream. They just do. Professor Liu does not believe judges are bound to apply the Constitution according to what it actually meant at its drafting or what it plainly says. But he believes judges are free to adapt the Constitution according to how they perceive the needs of modern society. In fact, he has written this: quote, "Interpreting the Constitution requires adaptation of its broad principles to the conditions and challenges faced by successive generations. The question is not how the Constitution would have been applied at its founding, but rather how it should be applied today in light of changing needs, conditions, understandings of our society." This is an untethering of a judge from law, in my opinion. He has also written that the Constitution has no fixed meaning. He's written that, quote, "Our Constitution has shown a remarkable capacity to absorb new meanings and new commitments forged from passionate dialogue and debate, vigorous dissent, and sometimes disobedience," close quote. He goes on to say, "Fidelity to the Constitution requires judges to ask not how its general principles would have been applied in 1789 or in 1868, but rather how those principles should be applied today in order to preserve their power and meaning in light of concerns, conditions, and evolving norms of our society," close quote. To that, I would disagree and say words do have meaning. They mean something specific, and when they are written down in a statute or a constitution, that meaning does not change by the mere passage of time or the mere shifting of political winds or the judge's personal views about what may be the concerns, conditions, and evolving norms of our society. Judges aren't empowered to do that. They're not empowered to impose their views about the concerns, conditions, and evolving norms of our society. Judges are given the power to decide cases and to say what the law means. For a judge to believe otherwise is a serious threat to the rule of law and to the principles that make this nation great. Professor Liu's writings express extreme views about more than constitutional interpretation. His writings have often expressed an unorthodox view of the role of a judge. Alexander Hamilton famously wrote in the Federalist Paper 78 that the judiciary has no influence over either the sword, the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, merely judgment. And frankly, having read his writings and listened to his testimony, for all his great capabilities and fine character, I have concluded that he indeed lacks the most essential quality of a judge, and that's good judgment, proven in the practice of law or as a previously appointed judge. I believe that Hamilton's was the role envisioned by the Chief Justice Marshall when he wrote, "It is emphatically the province and duty of the Justice Department to say what the law, the Judicial Department, to say what the law is." Close quote. I think Chief Justice Roberts perfectly summed up the role of a judge as the founders saw it and as we've been raised to understand it when he said that a judge should be a neutral umpire who calls the balls and strikes without preference to either side. But Professor Liu does not agree with that analogy. He attacked Chief Justice Roberts. He does not argue that the task of judges is to read the words of the Constitution according to their original meaning. Instead, he's written that, quote, "The historical development and binding character of our constitutional understanding demand more complex explanations than a conventional account of the courts as independent, socially detached decision makers that say what the law is. The enduring task of the judiciary is to find a way to articulate constitutional law that the nation can accept as its own." Close quote. This is utterly wrong. That view cannot be accepted because it calls for a judge to ponder, to seek to render a decision that is popular or fits the judge's own values. Most certainly such a decision method is not law. It's not objective. It's subjective. Really, it allows a judge to base rulings on factors that are incapable of being a standard. It introduces politics, ideology, religion, and whatever else may be in a judge's mind in a decision-making process. And that's contrary to the entire history of the American rule of law that served us so well. Mr. Liu has also written that, quote, "The problem for courts is to determine at the moment of decision whether our collective values on a given issue have converged to a degree that they can be persuasively crystallized and credibly absorbed into legal doctrine." Close quote. Well, these words describe a policymaker, not a judge. Professor Liu's writings also show that he does not share our founding fathers' vision of, in many different areas. And having confused my papers here, I better get this straight. He does not see the Constitution as a charter of freedom from government interference. Instead, he argues that portions of the Constitution create positive rights to welfare benefits. He attempts to derive all of these rights from the Citizenship Clause of the 14th Amendment. That clause reads simply this: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. It may be difficult to determine exactly what some of the words mean in the Constitution. However, our language has not changed so much that these words could possibly be read to mean that all Americans have a right to various benefits, such as, quote, and this is what Mr. Liu has written, quote, expanded health insurance, child care, transportation subsidies, I kid you not, job training, and a robust earned income tax credit, close quote. That's what he's written in several important law journals, not a casual conversation. He's written in law journal. He writes that the word citizenship does not mean citizenship in that clause, but rather, quote, the ability to be a fully able participating member of society, close quote. The Constitution didn't say that. The Constitution just made persons citizens. His article asserts that education, health insurance, child care, transportation, subsidies, job training, and presumably other welfare benefits you might need are constitutional rights because the Citizenship Clause ultimately requires equality of results in those contexts. He asserts that the judge's role is to ensure such a result is achieved even if the legislature may not so find. That's like no definition of citizenship I've ever heard. Professor Liu's interpretation of the Citizenship Clause is so far disconnected from the actual text of the document and what the people meant when they ratified it that it would be unrecognizable to those who drafted it. Some of Professor Liu's supporters have said, as he did before the committee, that his argument about the Citizenship Clause was directed only at Congress, legislative branch, the executive branch, and it was never meant to judges, but that simply does not square with what he wrote. And we've researched this, tried to be fair to him. In 2008, Professor Liu published an article entitled Rethinking Constitutional Welfare Rights. Constitutional welfare rights. In that article, he set out to make, as he said, quote, a small step toward reformation of thought on how welfare rights may be recognized through constitutional adjudication, close quote. That means by judges. Judges do adjudication. In that same article, Professor Liu argued that once a legislative body creates a welfare program, it is the role of the courts, he said the courts, to grasp the community meaning and purpose of that welfare benefit in light of the needs of equality and national citizenship. Professor Liu explicitly stated that when necessary, courts should recognize or expand these welfare rights by, quote, invalidating statutory eligibility requirements. This is his language. He wrote, quote, by invalidating statutory eligibility requirements, that means welfare eligibility requirements, or strengthening procedural protections against the withdrawal of benefits, close quote. Well, Congress withdrew and altered benefits with the Welfare Reform Act in the late 1990s. President Clinton eventually signed it. And does the judge think that courts ought to strike that down? Apparently so. In other words, Professor Liu believes that judges have the right and indeed the duty to rewrite laws written by Congress when they think those laws are inadequate or when the judge, without the traditional limitations of legal standards, decides the case on what the judge thinks is fair. It's too close to that. It really is. This is a dangerous, non-legal philosophy. His writings also show that he holds a number of views on some of the most controversial topics of our day that are extreme. He believes that the long-standing definition of marriage as between a man and a woman is unconstitutional. We asked him about that at the hearing, and frankly, his answer was not satisfactory in the sense that he said he was only referring to California law when, in fact, his brief cited the U.S. Constitution, which had similar language. He's also made statements that raise questions as to his temperament. He was very nice at our hearing. We've heard things said about him in that way. I would just ask if you consider these nice comments that he made about Chief Justice Roberts, for example. He said Chief Justice Roberts has, quote, a vision for American law, a right-wing vision antagonistic to important rights and protections we currently enjoy, close quote, and criticized him for being a member of, quote, the Republican National Lawyers Association and the National Legal Center for the Public Interest, whose mission is to promote, among other things, free enterprise, private ownership of property, and limited government. This is all Mr. Liu's writings. The mission of this Republican Law Center or the National Legal Center for Public Interest is, horror of horrors, to promote free enterprise, private ownership of property, and limited government. He considers those improper goals and says, quote, this is his quote, these are code words for an ideological agenda hostile to environmental, workplace, and consumer protections, close quote. Give me a break. With respect to Justice Alito, a fabulous member of the Supreme Court, so experienced, so far, so much more seasoned as a nominee than this nominee comes close to being, he went further, appearing in person before the Judiciary Committee to testify that Justice Alito, quote, envisions an America where police may shoot and kill an unarmed boy to stop him from running away with a stolen purse, where federal agents may point guns at ordinary citizens during a raid even after no sign of resistance, where a black man may be sentenced to death by an all-white jury for killing a white man, and where police may search what a warrant permits and then some, close quote. He acknowledged that was unnecessarily colorful language at the committee when asked about it. Nobody said that kind of thing. It was an intemperate remark, and it was unfair to Justice Alito. Thus, I have concluded that the nomination presents an extraordinary circumstance that requires me to oppose cloture on the nominations, which I'm reluctant to do. I voted against some nominees. I voted probably for 90% of President Obama's nominees, 90% of President Clinton's nominees when I was in the Senate. But this nominee, I believe, represents an extraordinary circumstance. His record reveals that he believes the Constitution is a fluid, evolving document with no fixed meaning, that he believes the role of a judge is to participate in a, quote, dialogue, close quote, with the legislature about what welfare benefits are to be required by the Constitution, and that the traditional definition of marriage is unconstitutional. His record reveals he's willing to use the courts in order to achieve what he thinks is the proper level of social welfare benefits, and that he is willing to attack even and distort the record of honorable judges to promote his own views of what he thinks the Constitution should require. Mr. President, I do believe that our Senate would have done better not to have had filibusters. That was my view. But we had a debate on that, and it changed. Now, Senator Boxer and other Democrats now have rethought that matter and would like to talk to me. I would certainly be willing to consider restoring the traditional view of the Senate with regard to filibusters of judges. I don't think that's likely to happen because it was done systematically and deliberately with great deliberation and determination by the Democrats in 2001, I believe it was, and they imposed that change on the Senate, and that's what we're operating under today. And based on that, I do believe that Professor Liu should not be confirmed. I thank the Chair and would yield the floor.
The Senator from Texas.
Madam President, I want to join my colleague from Alabama who has served for a long time on the Senate Judiciary Committee, as have I, in voicing my strong opposition to this nominee. It's odd, it seems to me, to have someone who's actually been nominated 3 separate times by this president. And I think it tells us something about the president's determination to nominate and see confirmed someone who is, I think, unsuited for service as a federal judge. Now, in saying that, it doesn't mean that they were, they don't have rights to speak freely about their strongly held views. In fact, they do. That's what we do, though, here in the legislative branch. That's not what we expect out of a life-tenured judge. We expect judges to be impartial and to render justice and to decide cases, not to be roving policymakers and making the country into their image of what it should be. Because judges, we can't vote for judges. Judges are once appointed, they serve for a lifetime. And in return for that lifetime appointment and that protection from the sort of accountability that other elected officials are required to have, we understand our Constitution provides that they have a limited but important role, and that is to apply the law as written, to apply the words of the Constitution as written, and not to sort of make it up as you go along or to dream up new rights along the way that aren't subject to a vote of the American people or subject to an election. So, based upon nearly everything that Mr. Liu, Professor Liu, has written or said, I have some very serious concerns about his impartiality and his suitability to serve as a life-tenured judge. My concerns start with his lack of judicial temperament. During the confirmation hearings of now Justice Sam Alito on the United States Supreme Court, Mr. Liu went out of his way to testify under oath before the Senate Judiciary Committee in a way that I can only describe as vicious and disgraceful. This is what he said. He said, quote, "Judge Alito's record envisions an America where police may shoot and kill an unarmed boy to stop him from running away with a stolen purse, where federal agents may point guns at ordinary citizens during a raid, even after no sign of resistance, where the FBI may install a camera where you sleep on the promise that they won't turn it on unless an informant is in the room, where a black man may be sentenced to death by an all-white jury for killing a white man, absent a multiple regression analysis showing discrimination, and where police may search where a warrant permits and then some." Mr. Chairman, I humbly submit this is not the America that we know, nor is it the America we aspire to be. These were the words of a person that President Obama has 3 times nominated to serve on the Ninth Circuit Court of Appeals, one of the highest courts in the land, that's expected to dispassionately decide cases without fear or favor or any preconceived notion about the outcome. But I think these words, perhaps more than anything else, demonstrate Professor Liu's unsuitability to serve as a federal judge. These were not an off-the-cuff set of remarks or a temporary lapse in judgment, but they were a product of carefully scripted and prepared testimony provided to the Senate Judiciary Committee during the Alito hearings. Despite Professor Liu's comments, Justice Alito was confirmed with bipartisan support. During his failed confirmation process last year, I asked Professor Liu that if given the opportunity, would he change anything about his remarks about Justice Alito. In response, Mr. Liu claimed that he regrets having written that passage, calling it, quote, unduly harsh and provocative, close quote. Well, Professor Liu waited 4 years to provide that semi-apology to Justice Alito for these shameful remarks. And like so many nominees who come before the Senate Judiciary Committee, they seem to undergo a nomination conversion that changes the tone and the nature of their remarks and their attitudes. And frankly, we just can't depend on this conversion sticking. We need greater assurance that the nominees who come before the Senate are going to exercise a sort of dispassionate judgment that we expect of judges. And frankly, Professor Liu has shown himself capable of incredibly poor judgment, and not just one time. After Chief Justice Roberts was nominated to the United States Supreme Court, Mr. Liu again went out of his way to criticize then-Judge Roberts. He argued that Justice Roberts' record, quote, suggests that he has a vision for American law, a right-wing vision antagonistic to important rights and protections that we currently enjoy, and that he's not afraid to flex judicial muscle to achieve it, close quote. In that same article, he attacked Justice Roberts' membership in the National Legal Center for Public Interest, calling its mission to promote free enterprise, private property, and limited government. He called those code words for an ideological agenda hostile to the environment, workplace, and consumer protections. So Professor Liu considers free enterprise, private property, and limited government code words for an ideological agenda hostile to the environment, workplace, and consumer protections. That's what he said. Is that the kind of person that we want, that the Senate should want, that America should want to sit in judgment, to enforce our Constitution and laws passed by the United States Congress? Well, I think not. And yet another dramatic nomination conversion during his failed nomination process last year, Professor Liu responded to my written questions by calling this statement a, quote, poor choice of words, close quote. A poor choice of words. Although there are several more examples of Professor Liu's lack of judicial temperament, his record is already crystal clear. Now, it's one thing for Professor Liu to disagree with a person. We do that every day here on the floor of the Senate and committee and around the country, across kitchen tables in our homes. But it's quite another to repeatedly engage in these types of inaccurate and, frankly, disgusting attacks against a public official trying to do their job the way they think they should be done. For Professor Liu to only reflect upon his statements once he's offered a life-tenured judgeship on the Court of Appeals is unacceptable. Given his lack of experience as a practicing lawyer, obviously his lack of experience as a judge, never having served as a judge, it's impossible for me to trust his assurances that now all of a sudden he will calmly and impartially apply the law as written by Congress or as written in the Constitution of the United States. I would cite just one other example of my experience on the Judiciary Committee, this one involving now Justice Sonia Sotomayor. Justice Sotomayor is a charming woman. She came into the Senate Judiciary Committee hearings and won over many people who were, frankly, a little skeptical of her nomination based on some of her previous writings and speeches. But I remember in one particular question, she was asked whether she accepted as an individual right the guarantee in the Second Amendment of the Constitution, the right to keep and bear arms. And she said she did. She accepted the decision in a case called the Heller case that said that that was an individual right of a citizen. A few months later, in a case called McDonald versus Chicago, she wrote a dissenting opinion from a Supreme Court decision where she said the right to keep and bear arms is not a fundamental right. Well, you can parse the words, an individual right, a fundamental right, but to me, it's clear that Justice Sotomayor, during her confirmation hearings, tried to parse the words in a way so as not to raise alarms about her commitment to the Bill of Rights and the Second Amendment to the Constitution. But then once she was confirmed as a judge on the highest court in the land, of course, she serves for life with no accountability either to Congress or to the voters, and she indeed serves with impunity, even though her testimony before the committee and her decisions once on the court, I think, are inconsistent. So we just can't take a chance that Professor Liu has somehow had a true conversion in his views and his attitudes during the nomination process. But aside from his questionable temperament, Professor Liu's activist views of the law are equally troubling. In his book called Keeping Faith with the Constitution, Professor Liu summarized this activist philosophy in this way. He said, quote, "Fidelity to the Constitution requires judges to ask not how its general principles would have applied in 1789 or 1868, but rather how those principles should be applied today in order to preserve their power and meaning in light of the concerns, conditions, and evolving norms of our society." What does that mean? Does that mean that the words on the page don't necessarily mean what they say? That a judge is somehow going to subjectively read into those words what the evolving norms of our society are and to change an outcome, to decide a case, to decide what our Constitution means based on their subjective impression of those words and what evolving norms in society means? Well, that's sometimes called a doctrine of believing in a living Constitution, that the words on the page are immutable or changeable and can morph over time into meaning different things based on a judge's interpretation of what those evolving norms are. But to me, that is a license to lawlessness. It is a license for a judge, an unelected, lifetime tenured individual who takes an oath to uphold the Constitution and laws of the United States, that is untethered to any concept of what the law means, something that can be applied with equal application to every man, woman, and child in America, and gives a judge a chance to impose their political or ideological views on what the Constitution means. That's dangerous. It's lawless. And it is not upholding the Constitution that we, even as members of Congress, swear to uphold in our different jobs as policymakers. Well, particularly troubling in his, for Professor Liu is his controversial and I would say ridiculous view that our Constitution somehow guarantees a European-style welfare state. We're engaged in a very important debate on the floor of the Senate and during the course of this vote on the debt ceiling, which I suppose we'll have sometime in July or not, with whether we are going to continue to be an opportunity society or whether we have become an entitlement society, a welfare state. But Professor Liu, in his article, Rethinking Constitutional Welfare Rights, has argued that the Constitution includes, quote, an affirmative right to health insurance, child care, transportation subsidies, job training, and a robust earned income tax credit, close quote. Well, I must have missed that in my copy of the Constitution. I don't remember the Founding Fathers writing in the Constitution, nor the states ratifying language in the Constitution that guarantees a right to a robust earned income tax credit. When Senator Sessions gave Professor Liu the opportunity to clarify his views in April 2010, he replied, quote, he said, "I do believe that, Senator, but those arguments are addressed to policymakers, not the courts." Close quote. Well, I think Professor Liu is being disingenuous, and I'm trying to be charitable. When he says the Constitution includes these rights but says those arguments are addressed to policymakers, not the courts, he's denying that a court that might agree with him would enforce those rights as a matter of constitutional law. This is not just addressed to policymakers. That's not being honest. I mean, I don't blame him if he has an honestly held view about these matters. I would welcome candor in expressing those strongly held views, but they are views more appropriately expressed in the court of public opinion, where we debate the values and meaning of our laws and what kind of country we want this to be, not in people who want to be judges and impose those views as a matter of judgment in an individual case, transforming the written Constitution into something completely different than what each of us can read on a printed page or what we learn in school our Constitution actually means. In other words, Professor Liu believes that the Constitution contains an unenumerated list of goods and services, an unenumerated list of goods and services like free health insurance, daycare, bus passes that federal legislators must provide to every citizen. It's not difficult to see how an activist judge might one day use Professor Liu's theory to force Congress to provide for these lavish welfare benefits, even though our country faces a historic debt crisis, as we do now. What's more, Professor Liu suggested that under his view of the Constitution, it may be unconstitutional to repeal certain welfare programs once they are enacted. For example, in Rethinking Constitutional Welfare Rights, Professor Liu wrote that legislation may give rise to a cognizable constitutional welfare right if it, quote, has sufficient ambition and durability reflecting the outcome of vigorous public contestation and the considered judgment of a highly engaged citizenry. Well, that's a mouthful. But what he's saying is once the legislature passes a law, the legislature has no power to repeal that law because it somehow then is transformed into a constitutional right and beyond the power of Congress to change. That's radical. Professor Liu's writings have also suggested his unconventional beliefs about the death penalty. He's expressed the views that it is unconstitutional, that same-sex marriage is a constitutional right, and that it's appropriate for judges to consider foreign law when reaching their legal conclusions about what American law means. Well, taken as a whole, Professor Liu's record demonstrates that he would use his position as a federal judge to advocate his ideological theories and undermine the well-settled principles of the United States Constitution. Madam President, that is simply unacceptable to me. I think it should be unacceptable to the Senate. And given his lack of temperament, his poor judgment, and his activist view of the role of judges and the law, I'm left with no choice but to fight Professor Liu's confirmation with every tool at my disposal. Madam President, I yield the floor.
Madam President.
The senator from Delaware.
Madam President, I rise today to continue to express my views and support